very interesting what this case is about. So let's go on the record on cause number DC 2016686. Lewis v. Lindsay. Counsel, make your appearances.
James Cruz on behalf of the defendant, Alicia Lindsay.
Brendan Mason for the plaintiff, Amanda Lewis.
Okay, I've read all the briefing. I'd love to hear y'all's argument on it.
Okay, Your Honor, thank you. First and foremost, the steps in the process for a slap motion to dismiss is that the communication needs to revolve around either right of free speech, right to petition, right of association. In the plaintiff's response to our motion to dismiss, they acknowledge that we've passed step one. On page 4 of their response, they specifically state, thus defendant, open quote, knew from the face of the pleading that the communication revolved around an open litigation, closed quote. That is precisely a definition, and the definition that is under exercise of right of petition.
Yeah, I don't see that as an issue. To me, the main issue is, I mean, your client accused the plaintiff of murder in a post to the world, and I'm not sure how that's protected by the First Amendment.
Well, Your Honor, and that's a good point. If we look at the language, and I can pull it up if I.
Yeah, that's fine.
Share screen. It says it's disabled.
Oh, I'm sorry. I need to enable that. I apologize. Go ahead.
Can everybody see that?
Yes.
Okay. The language that is alleged here is in this block quote, and the plaintiff has already said in the petition, and we're supposed to consider that in the surrounding speech, that this is a communication concerning a custody dispute, an open litigation concerning a custody dispute. And because we're supposed to consider everything when you consider defamation, we have to consider that. So when we look at it, the comment that they complain of is that I won't let y'all kill B like your mom killed your dad. In order for that to be defamation, as the court pointed out, there would need to be a statement of fact alleging the commission of a crime by the mother of whoever she is writing to. And in this case, that mother, the mother of that person is the plaintiff. So in order to believe that was a statement of fact, you would have to believe that the statement was alleging that the plaintiff's two daughters intended to commit a murder on B by the very language, by the plain language of the agreement. So if we're to take it even literal as they want to, then when we come down here, so why rob him of that? Then you'd have to say that she is telling the author, or telling whoever she's writing to, that she thinks that they are going to commit a robbery, the crime of robbery. That is not what this is about.
I don't think that's the same, though. I mean, so why rob him of that? I don't think that's a statement. But she says specifically, like, your mom killed your dad. I mean, that's indicating that the mom killed the dad, right?
Well, in the context of the entire communication and the entire thing, which we know is about a custody dispute, in open litigation, about a custody dispute, there's no way that you could. It's not an open litigation concerning a murder trial. It's concerning a custody dispute. There's no way that you could look at that and say oh, so the mother killed the father, because there's nothing in here that would say that anyone is trying to kill B. That the exact thing, of, they're bothering B, they're trying to harass B. That's what you would get out of it. It would be the same thing as the mom. You can't have the first part and interpret it as not killing B, and then interpret the second part as the mother killed the dad. You can't have it one way or both ways. You have to have it one way or the other. So if
I'm not following that argument at all. Okay. I apologize.
And that's fine, Your Honor. The point of the argument is the only way that you can take the mom killed your dad as a statement of fact that could be defamatory is if you were to believe that she is saying that she intends to prevent y'all from killing B. And we know that nobody is trying to kill B from that. Like there's no one is trying to murder B. So the only way that
how do I know that?
Because you're required to take the statement and the complainant statement as a whole under the entire context, which is, according to them, and they've told you, communication revolving a custody dispute. I mean, you can't take a statement in isolation. That is under defamation law. You have to take everything.
So you're saying that if I, as part of a speech, if let's call him Brad. If Brad decides to say as part of his speech, my neighbor shot my son, just as part of a big speech, that because it was part of his, and that wasn't true, that the neighbor wouldn't be able to sue Brad because it's part of his speech? I just don't see how the context in this case, it's a statement of mom killed dad.
Well,
I just don't know how much more clear you can be.
You have to look at what it is. You have to look at what the communication is about. So when they say,
isn't this really, you're trying to interpret this in a way, I mean, because you may be right, but you're asking me to dismiss this as a matter of law, that I have the right, or that any citizen in America has the right to accuse someone of a crime, and that a jury shouldn't even be able to look at this, that this should be dismissed at this phase in the litigation as a absolute expression of the First Amendment. And I just don't know. I mean, in your first year of law school, you're taught there's limitations on free speech. And one is you can't accuse people, you can't yell fire in a crowded theater. You can't accuse somebody of a crime that they didn't commit. I mean, this seems like basic, First Amendment law. It doesn't seem terribly complicated to me.
And Your Honor, you're right on that. I cannot go and post a statement that Judge Martin Hoffman killed Brad.
Okay.
I can't go post that online. But in the context of a custody dispute,
you can do that.
I could post online and say, Judge Hoffman's killing everybody. And that is not defamation, because number one, we have to take it in the context.
Defamation.
Well, we have to take it in the context of the communication. And that's what the law says. The court must consider the broader context of the speech and the surrounding circumstances. They have set the picture of what the surrounding circumstances are, a custody dispute. So if I am posting about a custody dispute,
so you can accuse people of murder freely because it's part of a custody situation.
Well, nobody has said murder. Killing is not, you're killing me could mean you made me laugh, you're upsetting me, you're making me work hard. I mean, it could have many meanings. That's
not how it's written here, though, right?
Well, no, right here it is written that
mom killed dad.
No, in the context of a custody dispute. And in order to believe that mom killed dad, you'd have to believe that y'all, the two sisters, plan to kill B. They plan to murder B. There is no, this is a custody dispute. That is a similar and the same, would be the same context of me saying, you know, the custody hearings today, you know, Judge Martin
Did
Hoffman
mom
is
kill
killing
dad? Wait, did mom kill dad?
Nobody's ever made that allegation. I don't believe so.
Then what does that even mean? Like mom killed dad, what does that mean?
Well, I would think that it
I mean,
would be
what, she
just
said mom killed dad.
I would take this
Mom
as,
did-
I mean, I take this as harassment, you know, and you know, with regard to the children in custody of children.
Mr.
I mean,
Mason, do you agree with
that's what
Mr.
she's-
Cruz?
Yeah, that's what she's alleging. I'll let Mr. Mason respond.
I'm afraid I can't join Mr. Cruz's perspective in terms of the context that he's applying to the statements here.
Do you think a jury should make this decision, or do you think I should make it now at this preliminary stage? What the meaning of these words are?
Your Honor, it seems very obvious from where I'm standing that even taking Mr. Cruz's assertions at his word, was really raising is saying that there should be a consideration of the factual circumstances around it to determine what context to put it in, which is the appropriate, form for a jury to be considering. I don't see any grounds to say, as a matter of law, it's just not defamatory.
Do you have any cases, Mr. Cruz, under the TCPA or summary judgment precedent where a court has taken a statement like this that is clearly defamation per se, but because of the context, it could be interpreted in a different way, that should be dismissed in the summary judgment or the TCPA phase?
Well, I have cases regarding the consideration of the broader circumstances in the speech. With
And I don't
regard to
disagree with
taking,
that,
you're talking
but-
about with the literal, taking a statement literally when it is clearly, when it's not intended to be taken literally.
Right. That I guess that's my point is it my role as the trial judge to say, as a matter of law, that this statement, because it could be interpreted in two ways, I should interpret it the way the speaker may have intended it, as opposed to the way it's actually written, that's a determination I should make, or is that a determination a jury should make?
Right. The proper legal grounds would be, you can make the decision if you can say that a person of ordinary intelligence would not perceive that statement as a whole and in light of the surrounding circumstances as a statement that this mother committed the commission of a murder. If an ordinary person the standard is, if a person of ordinary intelligence could not do that, that's the same thing as a legal factual sufficiency, that it doesn't.
I guess,
doesn't
I
get
mean,
to
when I read that, I assumed that the mom had killed the dad. That's what I assumed when I read it the first time. I guess that's, maybe I'm not of ordinary intelligence, but when I read it, I assumed that the mom had killed the dad. Now, I didn't assume that I wasn't sure that she had literally killed them, or if she had been mistreated him so badly he died, or I wasn't sure if it was murder or something else, but I assumed that because of the way it's written that she did.
Well, in order to be defamatory, it would have to be a murder, a crime. You could kill your wife because you're just such a jerk, your whole life to her that
I mean,
I
it
say,
could be
gosh,
murder.
you broke her heart. That's not murder, and that's not defamation.
Do you have case law that says that?
I can find. I'm sure. Maybe on the broke your heart. I possibly could.
That I should find that as a matter of law.
if you can find that a reasonable ordinary person would not taking the surrounding circumstances as a whole, could not find that or would not find that, yes, it's a matter of
I think a person of ordinary intelligence could interpret this literally, that mom killed dad, and that could be murder. I mean, it definitely could be interpreted that way. I mean, I don't know, but Mr. Mason, did you have anything else you wanted to say?
Yes, Your Honor. As far as Mr. Cruz's points in this context, I think it's especially misplaced, and something that we're not really addressing is the fact that the mother is really a third party to all of this. So there would be, I'd say, significantly more weight to what he was saying if his client had directed these comments to the other party in that custody disputes, then that could lend in, an ordinary person reading it to just see it as some sort of hyperbole. But she's referencing a third party that hasn't been brought up in the discussion. And the only thing she says about the mother is like she killed your father.
That's a good point.
As far as context goes, there's only one way to read that, because there's nothing else about the mother to put that in different context in this statement. And this defamatory statement is what we're suing under. And to the extent that Mr. Cruz is reiterating the fact that this is surrounding a custody dispute, and that's what should bring it under the auspices of the TCPA, I would just point to, if we look at the actual TCPA and the references, both in the statute and, diving more, the considerations the Supreme Court of Texas mentions in the In re Lipsky case in their motion. Even the Supreme Court starts off talking about the constitutional considerations at play, and in our Constitution, Article 1, Section 8 for the state of Texas Constitution, literally that section is titled Freedom of Speech and Press Libel. And in the exact same section of our Constitution that forms the foundation of our free speech rights, that same section ends by saying you can't libel, and entitling those who have been libeled to a jury trial. So to the extent that we're trying to bracket this off and saying, we don't want to force out free speech, we also got to consider the other protected right created in that same portion of our Constitution.
You want to say anything else, Mr. Cruz?
Yeah, last thing, and I'll be done. And if I could just screen share one more time, just all right. So when we're back here again, I'll reiterate here the fact that I won't let y'all kill B, and like is the operative word here, because Judge, you had said earlier, you didn't think that, in a reasonable ordinary person wouldn't think that he is telling y'all that they're going to kill B. So we're talking about like your mom killed your dad. If you don't believe that y'all are attempting to murder
I don't think
B,
that's what I said. I said I didn't think so. Why rob him of that meant robbery.
Well, on the statement itself, because the word like is used, it has to be, it's talking about the same thing. So if a reasonable ordinary person of intelligence couldn't determine that the first part, that y'all are attempting to murder B, then you could not determine that mom murdered dad, because they would be unlike, not like.
Okay. All right. How much time do I have to make a decision on this?
I'd have to look, but I think we're at, I want to say maybe 2 weeks.
Mr. Mason, is that right, or do you know?
I would have to go back to the
out.
record and check when this was filed. I'm not sure off the top of my head.
I can find out real quick.
but I just know for sure it's
Mr.
within
Mason, you
a
were
month.
also arguing, I think, that this is frivolous and that you wanted attorney's fees. Is that right?
That is correct, Your Honor. At the end of our response to defendant's motion, I pointed out that I'm not contesting that this is surrounding a court case bringing it under the auspices of the Citizens Participation Act. However, the second prong, as defendant put it, of that is this discussion we're having right here. And I think I think there is no fair way to say that as far as the evidence goes for presenting a prima facie case for each of our elements and these causes of action, that wasn't already apparent on its face. I'd go so far as to say that as a matter of law, we have at least satisfied that threshold burden. And due to the fact that that's the case and defendant hasn't brought up any defenses and shown that they can fulfill those, there was no way from the outset that they should or could be granted this motion to dismiss. So
you're saying it's frivolous and that I should award attorney's fees against the plaintiff, or against the defendant?
Yes, that second way, per the statutes, as we cited at the end there.
All right, I'll consider that.
Judge, I'm sorry, go ahead.
Go ahead, Mr. Cruz.
Well, I mean, it's obviously, it's not frivolous. We're making a arguments that make sense. The court might not agree with them, but that doesn't mean that it's frivolous. It's certainly, there's no allegation that was intended to delay. It is the frivolous part is normally if it doesn't apply to under SLAP, and they admit that it does, and the court said it does. It's whether
I have to admit, I haven't dealt with this. So the frivolous part is really just for whether or not it applies to SLAP, whether there was a affirmative defense.
Well, that's the only way I've. I mean, there's very few cases that I've seen where attorney's fees have been awarded against the movement, because this is the exact type of thing that is meant to get rid of these. If the court disagrees that that statement is a fact issue, at least, or wants to just push it to a summary judgment determination, that doesn't make it frivolous. Frivolous is that we have no basis in law or fact, and we do, because as we've said, under the circumstances of the communication, which the pleading set that out, a custody dispute, a reasonable person of ordinary intelligence could not take that statement as alleging the commission of a murder against the dad, unless you were to find or also believe that
Can I ask a
y'all
question?
are trying to kill bees.
This was posted on Facebook, or was this sent as a private message?
That was a Facebook post.
They have alleged that it was we're supposed to take the pleadings as they are. They've alleged that it was in connection with in response to a Facebook post.
So people saw this that didn't necessarily know the whole history about whether or not mom and dad or whether or not dad was dead.
Well, they said that it was a commentary regarding a custody dispute. So that it was in response to a commentary regarding a custody dispute. That's from what they tell us in the petition.
Okay.
That the statement, in fact, I think they say the communications that were that people were responding to revolved around an open litigation concerning a child custody dispute that extended itself from the bounds of the courtroom to the arena of social media, entangling a much larger and more varied cast of individuals. That's what they describe as this Facebook commentary that my client responded to. I mean, they set the tone of what it is, and they're not. This isn't a shady back streets of with bad people.
Well,
This is a custody.
the reason I asked that question was I know that there is case law. I dealt with this on a lot of different ways, this First Amendment issues on defamation. And so one of the issues that comes up is would the person who saw this reasonably believe that this is true? And so if it was sent directly to somebody, only directly to somebody who knew that mom did not kill dad, that was one thing. If it's a general post to the world, well, most people aren't going to know if mom actually killed dad. So that's what I was trying to get at. So,
yeah. And from what they've told you,
like
nobody would even know who.
What they've said is it went to the general, whoever was friends, I guess, of these people on Facebook.
And from what they've given you in the petition, nobody even knows who mom is. I mean, they have the burden of setting this all up, and we just have to go from what they've told us in the petition. So nobody knows with regard to that post who mom is. No one knows who dad is. No one knows who y'all is, except for they described one of the daughter's names.
Your Honor, may we respond?
Sure.
I actually want to go off of what counsel just said. Because nobody knows who any of those people are, they necessarily must also not know any sort of context that plaintiff or counsel is saying we should be putting this into, because they don't know them. So now the only thing they would know about my client is the assertion that she killed her husband, which I think undercuts what counsel's been saying for the majority of this hearing. And to speak further about that, your previous question about whether this is frivolous, the basis for my assertion in our response was that there's no legal foundation for the argument that counsel is raising here, that it's not grounded in law. I believe he's setting up I'll say, unique sort of binary choice that any reader has, where if it's defamatory, then you must also believe that they meant robbery literally, otherwise nothing makes sense, and no reasonable person would do that. So therefore, there's a legal foundation. I don't believe that's the correct state of the law. And if that's not the correct state of the law, and that's the only theory that counsel is presenting, then that means he filed a motion that could not be granted.
Okay. All right. Well, I will take this under advisement, and I will let you guys know as soon as I can about whether or not I'm going to grant this. If you want to do any very short one, no more than 2-page brief on this issue of if it can be interpreted more than one way, should it be do I have to interpret it the way that I guess you kind of set the standard? I don't know that that's that important, but and then also, is there any case law on frivolous under this? Because you're saying it's just for that first section. I'd not heard that before.
And
So.
no, that what I'm saying is we had basis under that. The second statement is we're looking at the whole that they set up, a custody dispute, and then we look and we see the word like your mom, and the argument is, and it can't be, I mean, I can't even imagine how it could be frivolous, that if you believe that she's saying that mom murdered dad, then you have to believe that she is saying she's going to stop a murder by y'all of B. Because if you're going to take everything literally, you have to take the whole sentence literally. You can't pick and choose and say, I'm going to get
why
rid of
can't
like.
you interpret it that way? I mean, I get that.
Because
that's
of
the
the
literal
word
way.
like. I won't let y'all kill B like your mom killed your dad. So it has to be the same.
So if I've seen this though, and I'm looking at this as someone who doesn't know what's going on. I mean, if you look at that literally, if mom killed dad, then she's saying, I'm going to stop you from killing B. I mean, that.
Well,
why
mom would have had
couldn't
to
you
murder
interpret
dad in order. It can't be defamation if mom
But the
drove him-
reader doesn't know that. I mean, she said mom killed dad.
So then the reader would have to also, because the word like is used, if they're going to take that literally, they have to also say that my client is writing this and basically saying, I am going to do everything I can. I'm going to stop y'all from murdering B.
Okay. All right. Thank you, guys. We'll let you know something in as soon as possible.
And Your Honor, the deadline to enter an order under 27.005A is 30 days after the hearing.
Oh, after the hearing. Okay.
Yeah.
All right. Thank you so much, guys.
Thank you, Your Honor. Thank you
Thank
for
you,
your
Your Honor.
time.
And we're going to take a brief break. Tony, you said you needed to take a break.
Yes, just real quickly, I just need to prove some work.
Okay. Are both sides here on the Taurus commercial case?
Your Honor, Taurus is here. Curtis Hubbard on behalf of Taurus. Jeff Dixon and Performance Construction, they're not represented by counsel.
Okay.
My guess is he is not going to be attending the hearing. I've sent him notice of the Zoom information, but I suspect he won't be here.
If you want to put anything on the record, we're going to have to wait. I can just sign the order if you want me to as well.
Yeah, mine is much easier than your previous hearing.
Yeah. Interesting hearing though.
Yeah, no joke. I caught the last 10 or 15 minutes. Yeah, ours is just a motion to compel. We have a judgment for just under $40,000. We sent out some post-judgment interrogatories and requests for production. And I've had a lot of communications with the defendant, and promises to pay, but has not gotten this information to me like he was supposed to.
Okay. Let me see if I can find this. And you sent an order in on it?
Yes, Your Honor. And this was originally filed some time ago.
Let's see. What do you know what day you sent the order? There it is. It looks on, well, August 6th. Okay, let me go.
There we go. Yes, sir.
Reagan, I'm about to print out the order if you don't mind grabbing it real quick. Okay. I'll go ahead and sign the order. Are both sides here on the Austin versus Villa Gomez case?
Thank you, Your Honor.
Yes,
Thank
Your
you. Have a good day, Mr. Hubbard.
Yes, sir. You too.
Plaintiffs are here. Ms. Carter's on, so I think both sides are here, Your Honor.
Good morning, Your Honor.
Good morning. How are you?
Good. How are you?
Good, good. You guys are moving for continuance on this. So do you need a record for this?
I don't.
Oh, Tony's back if you need a record, so.
I don't need a record, Your Honor.
No, thank you.
Okay. All right, let's go ahead and go forward on this. Go ahead.
Okay. You ready, Your Honor?
Yeah, whenever you are.
So just briefly, we do have an agreed motion for continuance. We had originally asked for at least a May trial date. That was prior to defendants designating some additional experts, and we're needing to schedule a variety of things. We do have mediation March 22nd, so we're hopeful we can get this one resolved. And if not, we recently filed a motion for summary judgment that we need to set up a hearing for. We have a couple of treater depots. The plaintiff is still treating, but we have a couple of plaintiff depots we're trying to schedule. And then it looks like we have looks like there's 4 defense experts we have 1 scheduled, 4 we still need to, and then we have a deposition of the defendant owner in April. So I was thinking probably a June or July trial setting is more realistic. And that's what we've requested, but Ms. Carter obviously going to give her a chance to talk.
Good morning, Your Honor. We agree. I'm Carrie Carter here for Fastel Transport. defendant. We agree that all of these things have yet to be done. They are outstanding. I don't think that I don't think that a June or July trial date is remotely reasonable, but we do agree on the continuance.
So there's two issues here. When is, if this was normal times, when would be the right setting? And then the other issue is, we haven't had a jury trial here for almost a year. So we have obviously, a huge backlog. I can set you in June or July. The one issue that's hard to figure is, when are we going to be back to jury trials? If you had asked me a month ago, I would have said it's probably not going to be until September. But with some of this more optimistic news on the vaccines, maybe we'll be sooner with the state of Texas kind of surprisingly reopening. That may affect when we go back to jury trials. I don't know. So that's kind of another issue of kind of how you want to, you're kind of gambling here. I will say that I hadn't been setting cases in June or July, although I have some very large cases set then.
I'm sorry.
No, go ahead, Ms. Carter.
No, I certainly didn't mean to interrupt you. I would just suggest that maybe following this hearing that the parties are able to get together and more look at the calendar and see if we can't get something figured out. But I think the biggest thing was just to advise the court of the status of this case at this point and recognize that certainly a March 31st, even under normal times, would not be feasible.
Okay, let me just look at something real quick.
Carrie, you have any thoughts right now?
I would really prefer Victor to talk about it after I've had a chance to look at. Unfortunately, I'm at home and I don't have access to everything I need
Okay.
for the calendar.
No problem.
And I know that because of the backlog, just like you, we are like utterly slammed in the summer and the fall with trial settings.
So let me kind of look at all this. So yeah, it's so I'm looking at the summer. We're pretty much filled up in the summer, but I mean, we're filled up even more so in the fall. We have between 15 and 20 cases basically set every week in June and July. August, it's between 15 and 20. I guess August 24th, we only have 14 cases set. In September, we have between 15 and 20. October 19th only has 12 cases set right now. So that's a possibility. October 26th only has 10 cases set. So maybe the October 19th or 26th.
Okay.
We would be open to that, but if Ms. Carter and I need to discuss and then get back to the court, I'm fine with that too.
That would be my preference, Your Honor.
Okay. No worries. And what I've been doing generally, I don't know if you guys have been in my court for this, but I do, and this is really hard to predict how this is going to go forward, but for now, I've been meeting basically with all the attorneys on Tuesday mornings for docket call. We just call everyone down and say, hey, look, we're going to have to reset all the jury trials. Let's try to figure out a date that works. So if you, assuming that's what we're still doing March 30th, which I think it will be, we can always do it on March 30th. But if you want to submit an agreed order with an agreed date, I'm happy to do that as well.
Okay.
I think that makes sense.
And
all right, guys.
Thank
you so much.
What was that October date again, Your Honor?
It's on Tuesday, so October 19th or 26th.
Okay.
Let me just see if there's any other dates. November 9th and 16th are not. That's surprising. Oh, this is weird. Okay, November 9th, 16th, and 30th are all pretty open, especially November 30th. That's really weird.
Okay.
And November 30th is actually a very good. How do I only have one case set then? That's weird. I guess people don't want to go to trial right after Thanksgiving. But yeah, November 30th, at least currently, is a pretty good date. So,
Okay.
another one to look at.
All right, we'll get together on that, Your Honor. I wasn't sure if this was on your, were you aware we had kind of slid in a motion to quash? Very, very brief issue in front of the court.
Mm-hmm.
Were you aware of that?
I wasn't, but I can hear it if you want to.
Okay.
If both sides agree.
Carrie, you good?
Yes.
Okay. All right. And so, Carrie, I got your email. Do you want me to pull up the motion for the court?
It might be easiest that way so he can see it. Your Honor, we only have, I think, 2 areas of dispute related to some corporate representative deposition topics.
Okay.
And these are employers of previous employers of the plaintiff. In this case, the plaintiff has a significant damages model, including lost wages and loss of earning capacity in the future. And to that end, we are seeking the deposition of some corporate representatives of a couple of the previous employers. And plaintiff has a concern about a couple of those areas of inquiry. You want to show those to the court, Victor?
Yes, real quick. And I believe, I'm going to double check. I believe both of these employers. Yes. So here's the timeline, Your Honor, just so you're completely in the loop. So after the wreck in question, the plaintiff worked for Whirlpool through Staffmark, and then after this additional logistics company. So these would both be companies the plaintiff worked for after the wreck, not before. I just wanted to make sure that was clear to Your Honor.
Oh, did I misstate? I'm sorry.
No, not a problem. So we had, there were only a couple issues we had. I think we condensed these down to number 5. And so on the subpoena corporate rep topics, the first topic that we had some concerns about, Your Honor, were they wanted any and all information relating to drug and alcohol testing of the plaintiff at any time since the time employed, including pre-employment, random, reasonable suspicion, return to duty, drug and alcohol testing results. And then I believe the other one that we were able to condense down to was 7B, which was any investigation performed by the company concerning the plaintiff, including but not limited to photographs, recorded statements, videotapes, background, criminal or credit records checks, surveillance, or interviewing persons. And the concerns we had, Your Honor, were number 1, the defense has had an opportunity to subpoena records already from these providers. So we were arguing that this was cumulative in addition to being overly broad, harassing, not within the scope of discovery in terms of any drug or alcohol test done at subsequent employment. I'm not sure how that would necessarily be relevant. Now, if there are documents that talk about termination, there was nothing in there about any failed drug or alcohol tests, I believe, for both of those employers. And just
my thought on this is the only thing that could possibly even, I'm not saying this would be admissible, but might be discoverable, would be if there were any failed tests that led to disciplinary action.
Okay.
So
And or termination.
Including termination.
Okay. And then obviously on 7, I don't even know if any, in terms of the documents we received, not sure outside of standard employment stuff, there was any investigation, but this is just kind of off the wall on surveillance and interviews and photographs and recorded statements. So, we had some concerns on that being overbroad as well, Your Honor.
So, okay, I'm unclear here. It says, so DSC Logistics, is that the defendant or is that the subsequent employer?
Subsequent employer, both at issue is just these requests for 2 subsequent employers.
I'd say the same thing if it led to disciplinary action. If there was an investigation that led to disciplinary action, they could get it. If it doesn't, then no.
And that, I think that's really what we're seeking. And maybe if we had included that terminology in the request, we'd have done better. Because that's what we're looking for, Your Honor.
Okay. Just get me an order on that and we'll go from there. Anything else, guys?
That's everything. Thank you, Your Honor.
All right. Thank you.
Appreciate it. Have a good
Thank you,
weekend.
Your Honor.